Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. First on the docket, Lori Hellis pulling out the big guns. We got a murder for hire case to talk about. The U.S. Attorney says Sherri Papini needs to spend a little more time than just 1 month in jail. An ex-state district attorney charged with murder from 1972. A video of some burglars being caught in the act of robbing an elderly couple just shows you have to be prepared. Those young criminals, they grow up so fast, don't they? That's right. It seems like just yesterday, Lee Malvo was terrorizing Virginia. Well, now he's all grown up and wants to get out. And then a very disturbing, dumb criminal of the day. Let's talk about it. Good day, aficionados. This is Crime Talk. My name is Scott Reich. It is September 16th of 2022, Friday, heading into the weekend. Have we got some good stories for you today? All right, before we get there, you know the drill. Subscribe if you haven't, like if you do, leave me a comment, hit that bell so you get notifications. And yes, you can remember, always listen to us on your favorite podcasting app. All right, first on the docket, Lori Hellis. For those of you who are not familiar, Lori Hellis is a retired criminal defense attorney. She's writing a book. Oh, and by the way, she's written a couple of motions that have been filed in the Lori Vallow, Chad Daybell matters. And, you know, she wants access to everything that's in the court record. I think she's correct. Judge Boyce has kind of harassed her, in my humble opinion, by citing rules that he wouldn't cite as it relates to anybody else. So she pulled out the big guns, all right? And I think it's worth noting, and we can try to put this up here for you as I read through it, but it's interesting. And then I want to highlight a couple of things. I think we may be getting close to the issues regarding prosecutorial misconduct. So let's sit down and listen to the letter written by Lori Hellis to Justice, that's right, Supreme Court Justice in Idaho, Gmᴎs. Why would she be writing to him? Well, he's the head of the media committee for the court. If you aren't familiar with it, Supreme Courts, they are the administrators of the courts. They're the ones that change the rules. But before you can do anything like that, before you can change the rules and say, oh, we're going to change this to a comma instead of a period, amend the rules, conduct disciplinary hearings, all those types of things, like any good governmental agency, what do they need? They need to have committees to study things for a long time till nobody cares about it anymore, and then suddenly they pass it. Well, they have a media committee in Idaho, apparently. All right. So this is the letter from Lori Hellis to Justice Gregory Moeller. Dear Justice Moeller, I am writing to you because you are the head of the media committee for the court. As I understand it, the Idaho Supreme Court either has or had a media and court conflicts resolution panel that was also known as the Fire Brigade. Unfortunately, I have not discovered how one refers a matter to this panel, so I am contacting you directly. I am a retired criminal defense lawyer, licensed and inactive in Oregon and Arizona. I am an author under contract with a publisher to write a book about the Lori Vallow and Chad Daybell cases. The case numbers are, and she cites them all, the case is assigned to your Fremont County District Court successor, Judge Stephen Boyce. I've been covering this case since the beginning, and I have recently found information that I find very troubling. Since the case began in March of 2020, Judge Boyce has ordered what is, in my experience, an unusual number of documents sealed. The number of sealed documents led me to research the criteria for sealing documents in Idaho cases. I discovered that Judge Boyce has not followed the procedure set out in ICAR 32. He did not hold a hearing after notifying parties and interested parties and did not make written findings. Her letter seems rather reasonable so far, doesn't it? As a media member, I filed motions on July 30th, 2022 to unseal the documents, filed a motion to intervene in the case, and challenged the sealed documents. Judge Boyce denied my motion on August 18th, 2022, finding that my motion to intervene was not a proper filing in Idaho. I revised the motions and refiled them on August 24th, 2022. I purposely omitted my home mailing address in my motion and sent it to the court in a separate letter. The court didn't accept that and rejected my filing the same day, pursuant to ICR Rule 2.3A4. I then rented a mailbox and refiled the documents on Friday, August 25th, 2022. The motions remained in the Fremont County Court's Odyssey e-filing inbox under review for 7 days before they were returned late on Friday afternoon for an error in the document footer. It's clear that the court has instructed the clerk to comb the documents for any mistakes and is playing games to avoid hearing the motions. I have now refiled my motions for the 4th time. As I'm sure you know, the Daybell case has garnered international attention. I write a popular blog about the legal issues in this case and have appeared on 2 popular YouTube true crime programs discussing the case. People interested in the case know me, so after I filed my motions to unseal the documents, I was contacted by an internet detective. This person is an avid internet researcher and gave me some troubling information. Here it comes, ladies and gentlemen. Is this the basis for the prosecutorial misconduct? Let's read on. Early in the case, the internet detective researched all the people involved and found some social media posts that bothered them. It seems that several people close to the case, including the judges, the prosecutors, and law enforcement officers, were posting inappropriate comments online. The internet detectives, who wishes to remain anonymous, documented their findings and sent copies to both the prosecution and the defense. Judge Boyce and Judge Eddings, prosecutors and law enforcement, may have been in a county employee Facebook group. It's difficult to substantiate since they have all scrubbed their social media accounts. Mr. Daybell's attorney, John Pryor, filed motions based on this information. First, he asked to dismiss the indictment because of irregularities in the grand jury. I speculate that at least one of the jurors must have seen the information in the Facebook group posts. Judge Boyce denied the defense motion. Next, Mr. Pryor filed a motion to dismiss the case and/or to disqualify all 3 prosecutors. Judge Boyce also denied those motions. Mr. Pryor then sought leave to file an interlocutory appeal of the decision. Today, the court held a hearing on that motion. The hearing was, of course, closed to the public. All motions, hearings, documents, and information associated with those motions have been sealed. I understand Judge Boyce has also issued a secret sealed gag order in the case. This level of secrecy is alarming and likely illegal. The First Amendment protects access to criminal matters to ensure that the government is doing its job properly. That transparency ensures that the defendants receive a fair trial and victims' families can be assured that justice has been served. It is impossible to fully explore the extent of the possible prejudice to the defendant in this case because of the level of secrecy. Yet each time Judge Boyce seals another document, he claims he is doing so to protect the defendant's right to a fair trial. In fact, it appears Judge Boyce has engaged in a systematic cover-up of the possible misconduct of the prosecutors, law enforcement, himself, and his judicial colleagues. As recently as August 25th, he entered another order reaffirming the sealing of all of the documents relating to the misconduct, doubling down. In the meantime, my motion to unseal the document is repeatedly rejected so that Judge Boyce does not have to rule on them and risk opening the documents. While the pretrial social media posts were ill-advised, possibly prejudicial, and in violation of the rules of professional conduct, specifically 3.6, it is the systemic cover-up of the information that is most troubling. Yesterday, Ms. Vallow's attorney filed a motion to exclude cameras from the courtroom for future court proceedings. Unfortunately, that motion has the potential to further limit the access of the press to the proceedings. Your Honor, I sincerely hope I am wrong, But as a former officer of the court myself and as a lifelong advocate for the rule of law and the Constitution, I can't sit by and watch these government officials subvert justice. I hope you can assist me in bringing this conspiracy of silence to the open." And signed it Lori A.G. Hellis, J.D., and it went to Judge Boyce, Judge John Schinderling, Rob Wood, Lindsey Blake, John Pryor, Jim Archibald, and John Thomas. So, is that the reason? Was it, in fact, that the prosecution or team for law enforcement was making inappropriate posts? Well, I don't know. I think Lori Hellis has been right on lots of things. I haven't seen any of these inappropriate posts, but if they're there, I think that would certainly be ripe for certain investigation. And maybe the court has made its ruling and perhaps it's well-founded. But until we get to see that, I guess we'll just never know. So the big guns are coming out. Judge Boyce won't give her an audience. Maybe the justice of the Idaho Supreme Court will give her some help with this committee that's supposedly there to resolve disputes between the media and the courts. I guess we'll have to wait and see how that one turns out. It's getting interesting, ladies and gentlemen. And you know what they say? It's not the crime usually that gets them. It's the cover-up, so to speak. So, yeah, we'll just have to wait and see. All right. Next on the docket, a 28-year-old registered sex offender in Rhode Island has been indicted for allegedly enticing a 12-year-old girl to engage in sexual activity and then hatching a murder-for-hire plot to prevent her from testifying. Okay, having done this case, ladies and gentlemen, I've done this a couple of times. Listen, ladies and gentlemen, you don't try to knock off witnesses. It never works. It fails every time. And then you get a murder-for-hire charge. It's just stupid. Face the facts. Makes you kind of look guilty, doesn't it? Anyway, according to a press release from the Department of Justice, Mr. Cardente is accused of repeatedly communicating with the minor female victim via social media beginning on December 3rd. And Mr. Cardente, who prosecutors say was falsely posing as a 17-year-old on December 10th, allegedly picked the victim up from her school in Burryville and engaged in some kind of sexual conduct with her. The minor victim was discovered on the side of the Jefferson Boulevard in Warwick approximately 4 hours after being picked up by Cardente. Law enforcement authorities subsequently arrested Cardente, detaining him at one of the Department of Corrections adult correctional institutions. Well, Mr. Cardente in February, while still in detention at the ACI, allegedly attempted to launch a murder-for-hire scheme aimed at eliminating the minor victim as a witness, right? We've all heard about it. No face, no case. One of the most important parts of any criminal case is they have to show identification. They need someone to come to court and say, that's the bad man that did those terrible things. Mr. Cardente must realize that. Hence the reason for his ill-advised plan. Well, Cardente communicated by telephone with another person. And remember, those communications are recorded. And during these communications, Mr. Cardente expressed his intent that the victim be murdered and offered $200 in cash and some equipment worth about $1,500, according to prosecutors. It's alleged in the indictment that Cardente told the other person that the victim needed to end up dead because she was a witness. Now, the person that Cardente spoke with while in detention was actually an undercover detective with the Rhode Island State Police. Of course they were. Now, Mr. Cardente apparently said, I got a 12-year-old witness and she needs to end up dead. You're okay with that? Cardente allegedly said to the undercover detective, according to the affidavit. Now, Cardente has a history of sexual offenses relating back to dates nearly a decade ago, according to the Rhode Island Sexual Offense Registry, which is maintained by the state police. Mr. Cardente was convicted in July of 2014 on one count of first-degree child molestation and one count of third-degree sexual assault. He was subsequently convicted of sex offender registration violations, i.e. not registering, back in June of 2019, as well as in September and November of 2020. Now, if convicted, enticement of a child is punishable by a mandatory minimum of 10 years in federal prison and carries a maximum sentence of life behind bars. and committing a felony offense involving a minor while being a registered sex offender is punishable by a consecutive term of 10 years of incarceration to any sentence imposed for the enticement of a minor. Interstate murder for hire is punishable by a maximum penalty of up to 10 years in federal prison. Past performance is indicative of future results, ladies and gentlemen. Just saying. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Sherri Papini, remember her, the woman who staged her kidnapping? Well, guess what? Prosecutors have recommended an 8-month sentence for Miss Papini, the California woman who pled guilty to faking her own 2016 kidnapping. Federal prosecutors suggest Papini should serve 1 month in custody and 7 months under home detention, according to the amended sentencing memorandum filed in the United States District Court for the Eastern District of California. Prosecutors said that an 8-month sentence, though on the low end of the sentencing guidelines, is consistent with Ms. Papini's plea agreement, and it fully and fairly accounts for the totality of Papini's conduct and the relevant sentencing factors, and is sufficient but not greater than reasonably necessary to satisfy the sentencing purposes, taken completely out of Section 18 United States Code 3355A. Okay. A lesser sentence, such as the 1 month of imprisonment recommended by the probation department or home detention in lieu of incarceration, is not sufficient to achieve the purposes of sentencing. Now, as you may recall, Papini in April pled guilty to making materially false statements to the FBI agents about the circumstances of her disappearance and committing mail fraud based upon her being a kidnapping victim. Now, the United States attorney said the 39-year-old was ordered to pay over $300,000 in restitution to the California Victims Compensation Board, the Social Security Administration, the Shasta County Sheriff's Office, as well as the FBI. Papini's disappearance early in November of 2016 sparked a 3-week search. She was found on Thanksgiving Day with various injuries, including a swollen nose and a brand on her right shoulder. But according to authorities, she had actually been staying with her former boyfriend, some 600 miles away from her home in Orange County, California. They allege that Papini inflicted the injuries on herself to back up her false kidnapping story. Prosecutors said she took her hoax even farther, even after she was found for applying for disability and victims benefits until she was arrested. These additional fraudulent acts suggest that Papini was not, as her therapist opines, merely coping with past abuse, but calculating to create additional benefits from her crimes, according to the prosecutors. And Papini's actions had a real negative consequence for the community and other victims. There needs to be just punishment for her conduct. The prosecutors say, and prosecutors recommended 3 years of supervised release. Can you imagine the community? I mean, my goodness, they believed her that she was kidnapped, as opposed to being a little skeptical sometimes. I'm just saying, ladies and gentlemen, just saying. Sometimes you got to be skeptical, even of the cases where you think, wow, that's really sad. Wow, that's really bad. You got to be skeptical sometimes. The old trust but verify. Next, another story you just can't make up. A former Nevada attorney general who ran for the Nevada Supreme Court with the infamous Mustang Ranch brothel has been arrested in Reno as a suspect in a 1972 homicide in Hawaii. Now, Tudor Chirilla, Chirila, he's 77 now, but he was being held at the Washoe County Jail without bail on a charge of being a fugitive from another state. Now, in a criminal complaint accusing Chirilla of second-degree murder, the Honolulu police said DNA evidence linked him to the fatal stabbing of then 19-year-old Nancy Anderson. The Honolulu Star-Advertiser first reported that Chirilla was arrested Wednesday, 5 decades after police say he stabbed the teen more than 60 times and left her body in her Waikiki apartment on January 7th of 1972. Anderson had moved to Hawaii in October of 1971 and was working as a McDonald's restaurant after graduating from high school the year before in Bay City, Michigan. The criminal complaint filed this week in district court in Hawaii said police had reopened the cold case multiple times since the killing and received a tip in December that Chirilla could be a suspect. In March, police obtained a DNA sample from Chirilla's son, John Chirilla of Newport Beach, California, that identified him as a biological child of a DNA sample found at the crime scene, according to the criminal complaint. Then, on September 6th, Reno police served a search warrant and collected a DNA sample from Tudor Chirilla at his apartment in Reno. 2 days later, he tried to commit suicide, always a good indication of consciousness of guilt, and on Wednesday was booked into the county jail in Reno. Over the years, police in Hawaii investigated multiple suspects, including door-to-door knife salesmen who were there to try to sell knives hours earlier, but the salesman volunteered fingerprints and passed polygraph tests. Other potential suspects questioned over the years included Anderson's former boyfriend and the property manager where she lived. Chirilla, a longtime attorney in Reno, Carson City, and the Lake Tahoe area, served as the Deputy Attorney General in the late 1970s and ran unsuccessfully for the Nevada Supreme Court in 1994. In a 1998 federal indictment, U.S. prosecutors in Reno identified him as the former president of a company called AGE Corp. that served as the front for Nevada's brothel boss, Joe Conforte. The indictment accused Conforte and others of being part of an elaborate conspiracy to defraud the government in bankruptcy proceedings when the Mustang Ranch east of Reno was seized by the IRS, sold for back taxes in 1990, and illegally repurchased by Conforte and his cohorts. The government claimed Conforte hid his assets during bankruptcy proceedings to cheat the government and buy back the legal brothel under hidden ownership. Now, testifying as a government witness, Chirilla acknowledged he knew the corporation was owned and controlled by Conforte, who had disappeared and was believed to be somewhere in South America when the case went to trial back in 1999. Chirilla filed suit against Conforte in 1998, seeking $14 million in alleged damages, alleging that Conforte wrongfully fired him for cooperating with federal prosecutors. Take a look at this video. Virginia police are searching for 2 suspects who robbed an elderly couple in their Portsmouth area home on Wednesday night. The incident happened at a residence off of the 2600 block of Turnpike Road at about 1:50 p.m. The Ring camera captured the moment 2 men dressed in dark clothing forced the couple by gunpoint into the living room. Police say the pair stole a wallet and a safe before fleeing. They could be driving an orange 2017 Dodge Charger with Virginia tags UBS 7788. The suspects have been identified as Mitchell Bonney Jr. and Tyree DeMont Bonney Jr. Both are now wanted on numerous charges, including burglary, conspiracy to commit burglary, abduction, and use of firearms. Just goes to show you, even in the middle of the afternoon, you have to be careful in your home. Always check with a local attorney as to what the make my day laws are before you do anything crazy. But your home is your castle, ladies and gentlemen. Next on the docket. They grow up so fast, don't they? They do. Well, the Virginia corrections officials have denied parole to convicted D.C. sniper Lee Boyd Malvo, ruling that he is still a risk to the community 2 decades after he and his partner shot and killed 10 people. As you may recall, Malvo was just a young 17 years old when he and John Allen Muhammad killed 10 people and wounded 3 others over a 3-week span in October of 2002. Several other victims were fatally wounded across the country in the prior months as the duo made their way to the nation's capital region from Washington state. Now, Malvo was convicted of capital murder in Virginia and sentenced to life in prison without parole. However, a series of Supreme Court rulings and a change in the Virginia law gave Malvo the opportunity to seek parole after serving nearly 20 years in custody. That's right, it's been 20 years. But the Virginia Parole Board said, oh no, we're not doing this. And they rejected his request, finding that Malvo still 20 years later, remains a risk to the community, and release at this time would diminish the seriousness of his crime and the serious nature and circumstances of his offense, the parole board said in their denial. Now, Malvo's accomplice, John Allen Muhammad, was executed in Virginia in 2009. Malvo, who's now 37, was sentenced to life without parole for the 3 Virginia killings. Then after the U.S. Supreme Court ruled in 2012, the mandatory life sentences for juveniles were unconstitutional. 2 federal courts found that Malvo was entitled to new sentencing hearings. And then the Virginia legislature also passed a law in 2020 that gave juvenile offenders an opportunity to seek parole after serving 20 years. Now, Malvo was a 15-year-old from Jamaica sent to live in Antigua when he met his much older Muhammad. Muhammad trained and indoctrinated Malvo. And in 2002, the pair embarked on this nationwide killing. As we stated, winding up killing 10 slayings in Maryland, Virginia, and the District of Columbia. Trial testimony indicated that shootings were a plan for Muhammad to regain custody of his children by killing his ex-wife and making her death appear to be the result of random violence. Even if Malvo had been granted parole in Virginia, he received a life sentence in Maryland for his crimes in the neighboring state. And last month, Maryland's highest court ruled that Malvo must be resentenced for his crime there, which means more than likely he'll be eligible for parole at some time, given the Supreme Court ruling that said juvenile life without parole is in fact unconstitutional. And Mr. Malvo is serving his sentence, don't worry, because he is a danger to the community at a maximum security facility in Virginia. I'm going to bet the chances of him getting out are slim to none. You got to give juveniles on a life parole sentence, you got to give them parole, and they can't serve life, so they'll get out at some point, but they're going to keep him as long as they can. Okay, finally, our dumb criminal of the day. And this is a little sick dumb criminal. I hope this woman gets the help she needs, and I hope she's got some mental illness that explains this conduct, because I don't think anybody's this dumb. So here we go. Hold on. If you've got kids around, you may want to cover their ears, all right? In a series of vile Snapchat videos, a 26-year-old mother of 2 recordings showing herself engaging in sexual activity with her 3-year-old son, and while breastfeeding her younger child, also filmed the family dog licking her private parts. That's right, Natalie Wagner. Remember that name, ladies and gentlemen. I don't think you should let her watch your kids. She's facing scores of felony counts in connections with 15 separate videos that investigators received last month from Snapchat following the issuance of a subpoena. Now, Miss Wagner is being held at the St. Lucia County Jail in lieu of a $1.2 million bond. Until her arrest last month, Wagner shared a Port St. Lucia home with her husband and the couple's 2 young boys. At the time of the Wagner's bust, the minors were removed from the residence by child welfare officials. A judge has barred Wagner and her spouse, who has not been charged, from having any contact with the children. Police noted that when they first questioned Wagner at her home on August 11th, her eldest son was wearing a Spider-Man t-shirt similar to the one worn by the victim seen in the Snapchat video. And a photo of the child's bedroom shows a large Spider-Man doll sitting atop the boy's bed, which is covered with a Spider-Man comforter and a pillow. Painted on the wall above the bed is the boy's name and the likeness of the Marvel superhero. Wagner, who works as a receptionist as an optometrist officer, reportedly told cops that she provided adult content to anyone that contacts her OnlyFans page and that she's in need of money. Various social media accounts, Wagner has advertised her OnlyFans and Feet Finder accounts and has published a price list for offerings like $10 lactation content, $10 bathroom content, FaceTime video calls, which cost $25. Now, Snapchat produced 15 videos that cops say created and uploaded between April 5 and May 9 and showed Wagner was actively victimizing her biological children. The affidavit provides a description of the recorded depravity. In several videos, Wagner is sitting on the toilet naked while a dog licks her private parts. In 4 of these clips, Wagner is breastfeeding her 1-year-old son while engaging with the canine. Other videos show Wagner pleasuring herself in the presence of her children. We're just going to stop right there. I think that's enough. I think you get the picture. Miss Wagner, I hope you're sick and not just dumb, but I think you're just sick. Anyway, that's all we have for today. Thanks for watching. We'll see you next time on Crime Talk.